Any mention?
Yeah, please, Your Lordship, I beg to mention item number 5, Kumar Lindo. I pray for 2 weeks' time.
You're appearing for?
Item number 5.
No, appearing for which
MTDC.
party?
Respondent number 2.
Private respondent?
The MTDC. Private
MTDC.
respondent.
You're for the petitioner?
Yes, sir.
Any objection?
No.
Okay, on the request of made on behalf of the private respondent number 2, list this matter after 2 weeks. It's all at 2 weeks. After 2 weeks.
All right. Please, Lordship.
Yes.
Lordship, I beg to mention item number 18, Your Lordship. I have informed to the GHTC Council also. I am for the petitioner.
At number 18?
Lordship.
Yes.
I seek some indulgence maybe after 2 weeks, Lordship. I just pray, Lordship.
No objection, Your Lordship.
Okay, on the request of the petitioner, list after 2 weeks.
May I please, Your Lordship? I beg to mention item number 12, Your Lordship. Let this matter be taken after 2 weeks, Your Lordship.
Yes.
Lordship, here I am for the petitioner. It's for the...
So you have an adjustment. One matter will mention, the other will mention.
No, it's not like that, Lordship.
Not like that.
Coincidence.
Mr. Sangupta, you were there?
Yes.
In this matter?
Yes.
Yes.
Let this matter be taken after 2 weeks, Your Lordship.
You are appearing for respondent number?
Respondent 3 to 5, Your Lordship.
Respondent number 3 to 5? After 2 weeks.
Yes, Your Lordship. Much
First
more, Your
place,
Lordship.
Lordship, I beg to mention item number 3 of the main list, Lordship.
3, the first item.
Lordship, the arguing counsel, Miss R. Dattam, Lordship, she is in bereavement, Lordship. That is.
Mr. Khan.
Yes.
Lordship, in this matter, we are supposed to arrange and produce the copy of the report.
Item number 3.
Lordship will recollect. Lordship, we have written to the department and still waiting instruction, Lordship.
It's all right. And see, even petitioner is also seeking.
Absolutely, Lordship. Please kindly give us some more time.
Just say after
2 weeks.
After 2 weeks, Lordship.
2 weeks.
2 weeks, Lordship.
Okay, on the joint request made by the parties, list this matter after 2 weeks.
Lordship, Lordship, I have similar prayer for item number 16, Lordship.
Name.
16.
Yes.
This matter is being handled by Miss Aditya, Lordship.
Who is the other side?
Your Lordship.
Item number 16. Is the state respondent?
Thursday 1 to 6, Your Lordship.
You have any objection?
No, Your Lordship, but only thing is that they're supposed to amend the petition, implement the managing committee. So since
There is an order passed by
yes,
the
so
court.
there's a order on 23rd August, but till now,
That part will I'll have to. I am not privy to the brief, Lordship, of this matter.
You're not there in the matter.
I'm there.
If you say you are not privy to the brief,
Lordship, it is being handled by Miss Aditya.
just
let Madam
any
Data
other
come,
list,
yes.
list this matter after 2 weeks on the request of the London Council. 16.
Similar prayer for item number 1.
At number 1, why, Mister? This is a 2014 matter. And what do you have? You see, like here.
Let it come, Lordship, after
That is regard to subsidy, that case.
Lordship, central subsidy.
This is spending unnecessary. I do not know how much this High Court can help you. Even if you have a case also. Last mechanism we have to go and you see like see the correctness of the rates and all.
Lordship.
Yes.
Lordship.
No objection. No. Happy it is adjourned. Okay, item number 1 also. On the request of the London Council of the petitioner, list after 2 weeks.
Lordship, Ali oblige.
May it please your Lordship. Lordship, I beg to mention item 2 of the hearing list.
Yes.
Chair, I'm praying for some time in this matter, Your Lordship.
On behalf of the petitioner.
Your Lordship.
On behalf of the petitioner.
Petitioner, Your Lordship.
I am for the respondent, my lord. There, the one name, 2 schools. My lord has already heard one occasion. So the teacher is claiming
That's salary for certain period of time.
certain period of time, where we are saying she was already out of the school and she was already terminated, and thereafter she opened another school by the same name, and that is the issue which has.
We are claiming the amount during the time which we were in the school.
You were I think, offered something also, but then you did not
We were
have it.
offered, but it
Did not
did
accept.
not come up.
There is an effort to settle the matter.
But it failed.
So, why to keep these small matters pending just? If it is salary for small things, see 2014 matters, you are fighting for salary of maybe for few months.
Few months.
And see, so you are
Your
almost
Lordship,
10 years.
the
What will
matter
gain?
here is not only regarding salary, it's also because there are two schools in the same name. So we have to determine the genuinity of one school. Now that there are two schools, we could not come up.
And in a read proceeding, my lord, we have the government. We are saying the school which is run by the other administrators is the original school, and the school run by the petitioner is not the original, and it's a fake school or whatever we call it. So it will be difficult for a read court, my lord, to determine the disputed questions of facts also, my lord, if that be the plea.
Anyway, just we'll have it.
3 weeks, my lord.
Why 3 weeks?
2 weeks.
She is not asking for even 2 weeks. She is asking for 1 week.
No, otherwise, my lord, there is no urgency in the matter since so long. They have kept it pending. We have made all attempts to get it.
Just after 2 weeks on the request of the learning counsel of the petitioner. See, these cases, few matters actually we should not keep. These are 2014 matter, and this court is not very much inclined to adjourn those matters.
I
Please
apologize,
take care.
Your Lordship. Lordship, similar prayer for item number 9, Your Lordship.
This is also removal of signboards on the national highway and the state highways.
Oh yes, there also you are supposed to take some instruction.
Your Lordship, we are still trying to contact the petitioner, Your Lordship.
If petitioner is not interested, then we will close the matter. Then.
Your Lordship will contact them once and
These are all unnecessary pending matters.
Your Lordship, in this matter, the state doesn't even have a policy as
Your
with regard
hoardings
to
have
the
been
hoardings.
removed in 2017 or maybe before that.
But Lordship, we have already paid our taxes to the municipal,
Not all.
which is not.
We heard this matter at some length. So far as the claim of the association is concerned, and their individual members are concerned, they all stand in different footings. And your
Lordship,
petition also does not disclose how many members are there, who are aggrieved, whose
It
contract was
is there,
subsisting.
Lordship, in the petition when they have given the authorization to the president to.
There is a resolution, but then it doesn't say how many members.
Lordship, I'll seek instructions with regard to that matter.
On the last occasion, probably it was hard at some
Yes,
point.
my lord.
It was heard.
And I do not know whether you were there or not, but then maybe somebody else was arguing the matter for the petitioner. And those things came up for discussion. So in
Lordship,
that situation, what was the submission advanced on your behalf was that you will take instruction. You were there, Mr.
Some
Khan.
restriction was there. Lordship is correct. In fact, they sought for time. Lordship had categorically stated that kindly come whether the association was member specific, and they said they'll come back with those details.
It was pointed out to the court
Yes.
that you see, like for certain members, the time allotted already expired.
Absolutely.
The time allotted. So they did not have any subsisting right at that point of
Absolutely.
time.
And the Lordship had directed them that kindly come with something specific details.
Madam, these are all 2017 things. Kindly take care.
Kindly
Help the court to dispose of this.
Lordship, next day I'll come with
If
instructions.
nothing comes out, what purpose would we serve by keeping it pending? You see?
Lordship.
Your small instruction can help this court to dispose of it.
Absolutely. If they,
Lordship,
have
on the
a,
next day, positively I'll come with instructions.
Lordship, if they have a case on that particular issue, then they have a case to agitate. If doesn't have a case,
Definitely, then definitely.
they can come with a new cause of action. They can come with a new cause of action.
Anyway, item 9. This also on the request of the learned counsel of the petitioner, list after 2 weeks.
Highly obliged.
Obliged.
Item number 4.
Yes, Lordship.
Another 2015 matter, yes.
Lordship, I pray that this matter comes up after 2 weeks.
Where is Nangri, Mr. Nangri?
Your Lordship, he is indisposed, Your Lordship.
My lord, I do not have an objection.
You were ready for the adjournment.
My
If
lord,
not ready for
Advocate
the
General
hearing,
is the counsel who is Advocate General is arguing from the respondent side. They have informed priorly, so I have also informed him. So, my lord, we do
that
not
is
have an
what
objection.
you were ready for the adjournment, isn't
Otherwise, he was ready, my lord.
it? You were prepared for the adjournment.
My lord, no, not exactly.
Not exactly.
We were prepared for
So
the
you are
matter.
ready
my
for
lord.
hearing then?
My lord, yes.
Okay. This pass same order on the request of petitioner after 2 weeks. List after 2 weeks.
I'll oblige, Your Lordship.
May I please, Your Lordship, I beg to mention item number 6 and 7.
Mr. Jha.
Yes, Your Honor.
Yes, what happened?
He's sick.
Is he really sick or
Yes, Your Lordship.
is sick for the purpose of these cases?
No, Your Lordship. Suffering from cold and cough.
No objection. Yes. 2 weeks on the request of the Lord. 2 weeks?
Yes, Your Lordship.
7, 8. There also, 8 also you responded.
No, Lordship.
6,
6
sorry, 7
and
also you
6 and
responded.
7.
6 also you responded. To a petition under the cases. Yes. 2 weeks on the request of the Lord Counsel of the petitioner.
Highly obliged.
Your Lordship, I pray for item number 14. Can this
Anything remaining?
item number 14?
There is the last item in the hearing list.
I don't know. Can this matter pass over for a day, Your Lordship?
Yes.
No objection, Your Lordship.
Two weeks on the request of the Land Council.
Much obliged, Your Lordship.
Please, Your Lordship, I beg to mention item 19.
19?
Yes, that this matter may become out after 2 weeks, Your Lordship.
Mr. Chakraborty is not well till now.
He went for checkup.
He's all right. Mr. Chakraborty is all right now.
Today he went for checkup, Your Lordship.
Okay, this association of power engineers, last item. Make it 3 weeks on the request of the Land Council of the petitioner.
Highly obliged.
Yeah, please, Your Lordship. I beg to mention item number 13 and 15, Lordship. 13 and 15.
13 and 15.
For 2 weeks, Lordship.
Yes. Yeah, for the petitioner.
Yes, Your Lordship.
Yes, where is Mr. Nongklau?
He out of station, Your Lordship.
This matter that compassionate appointment, seniority and all those.
Yes. In fact, my lord, he had informed me yesterday because I happened to go to lower court, my lord. So he had already informed me, my lord, that he'd be taking time.
And who is the respondent for item number 15?
Lordship, this is regarding the payment, Lordship. The company
Withdrawal of salary. Recovery.
Yes,
Recovered here.
no.
That is, recovery has not been made. Only notice has been issued. And this staff is a grade 2 and grade 3, grade 4. Grade 3. So it is not recoverable, isn't it?
No, Lordship. But then in this case, she has already given an undertaking, Lordship. That she will reimburse back whatever has been overthrown.
Conflicting judgment of Apex Court.
Lordship. And Lordship, there was a judgment of this court also which has directed that the company may not be made when undertaking has been.
No, but then where recovery has been affected? Here recovery has not been affected. Isn't it? Was it the situation? No. Anyway, we'll see to it. 13, 15 both on the request of the London Council or the petitioner, list after 2 weeks. Yes.
May I please, Your Lordship? I beg to mention item number 10, Your Lordship. I pray for 3 weeks' time. Yes, Your Lordship.
Wait, let us see what is item number 10. Yes, Mr. KP, what is this matter?
My lord, this is a matter, my lord, where the petitioner was initially my lord, appointed as
Service matter.
as instructor, my lord. It's
It is
regarding-
service matter.
Yes, my lord, service matter. Polytechnic. Pertaining to Shillong Polytechnic College, my lord.
What, selection, an appointment or?
My lord, he was initially appointed as instructor, my lord. Now what he is claiming is that you please give me a post in a post of assistant lecturer. My lord, what had happened in between, he had.
Promotion. It's a promotional post or?
No, my lord. What had happened is that he had already tendered his resignation also. Thereafter, he never joined service also.
He is not in service now.
No, he's not in service.
2018 matter, what is the purpose of keeping it alive then? Do you expect after 5-6 years you will get back the job? These are all unnecessary matters. Okay, after?
3 weeks, Your Lordship.
Why 2 weeks? Give 3 weeks. No objection otherwise, isn't it? On the request of the Lord Council. Yes.
Highly obliged, Your Lordship.
Right.
Yes, Your Lordship. Lordship, like to mention item 11.
You still have something left.
Lordship, here in the, it was a part-heard matter, but during the course of hearing, we had relied on one judgment. Now that judgment is pending before the division bench. On that count, the matter was.
Oh, so that Mr. Chando argued that.
Yes, Your Lordship. Promotion matter. That, the appeal is listed on 20th November, Lordship.
20th of this month?
This month, Lordship. When we come after 3 weeks, then, Lordship.
Just after 3 weeks on the request of the Lord Council for the petitioner.
Okay.
Submit release. Item number 1.
Socialized matter. Yes, socialized matter. So should have told me to appear.
Will this be with me?
Yes, Mr. Sangma.
Yes, Lordship, this is I'm coming for washing of the FIR. Now, what happened, Your Lordship? The
Pokso matter.
case, not Pokso matter, Your Lordship. This is, I will just submit, Your Lordship, that the Lordship is aware of the Supreme Court in order that is 0307/2019 in the state of Meghalaya versus or Dimasa Student Union. That case, Lordship, whereby Supreme Court has banned red horn mining and illegal transportation in entire state of Meghalaya, upholding the order dated 17/4/2005, this passed by the NGT. Now, there was no respite despite of the Supreme Court order. That's why Lordship is aware that this High Court of Meghalaya have taken a sumo to case.
Supreme Court order?
Yes, they
continued to violate it.
Yes, violated. Therefore, then in the order, Justice B.P. Kakati retired was appointed by the High Court of Meghalaya to oversee whether the direction of the High Court and or Supreme Court are comply by the yes, Lordship. That's the Lordship. Yes. Now what happened? My case is happened since Justice Kakati was appointed as to oversee whether the order has been complied. So any person or interested anybody who is see this illegal red horn mining is happening. So this petitioner, he just file a petition, the complaint petition to the Justice Kakati saying that there is a illegal coal mining happening in that particular area. He has specified that place also, that 3 villages. And on the basis of his complaint, Justice B.P. Kakati has taken cognizance of the same, and the Joint Secretary to the Government Meghalaya Mining and Geology Department have issued notice also to the this present petitioner saying that you can participate in the inquiry, and both Justice Kakati and some government officials along with the petitioners, they have all along went to the South Garo Hills, Bakmara near Chokpot into particular places, and it was found that there was some allegation that seems to be true, that there was illegal red hole mining was going on in that particular area. Now, after the inquiry has been made, then the Justice Kakati has reported High Court, that report to the High Court, and then after the matter.
The report said that your complaint is correct.
Yes, it was report was it seemed that it was correct. Now this police officer and these 2 villages private respondent, He have filed a force and complaint against me. The FIR itself is revealed through your lordship. May I just read
Private
the
response
FIR?
are cold reader.
Lordship.
Are they cold reader, private response?
Yes, they are the headman of that particular.
Nokma.
Now in the FIR also it's revealed that may I read the very interesting part of this one. This is a false and concocted FIR has been filed against me. Now, Lordship, the FIR I have enclosed page 54, Annex 11, Lordship. If Lordship require, I will just read it. So matter will be make it clear to how it is.
Yes,
Lordship.
Please.
I will just read it. This one. The FIR officer is so and so. FIR against Sri Fleming Marak so and so so and so. Sir, approach to the subject so that above we the understand Nokma of respective Akung land beg to lodge this FIR to the effect that the above named so-called social activists has lodged a complaint with the Justice retired Bojendra Prasad Kakati alleging that Rampam red hole mining, illegal mining is presently going on in our jurisdiction at Jetragri, Budugri and Darangri area, violating the ban imposed by the National Green Tribunal and Supreme Court. That it appeared that the daily newspaper, the Shillong Time, dated 28 so and so, in caption of activists alleged red hole mining in South Garo Hills, where he falsely accused and implicated the district administration, the police department, and even the Meghalaya government being not action taken seriously prevent the illegal mining in the district. Also, he submitted a false representation image of coal mining to the Honorable Court, extracted copy of so and so and so and so. It is to be mentioned that on consideration and admitting his petition, the Honorable Court has constituted the committee headed by retired judge of the High Court, to inquire into the alleged matter with a direction to spot inquiry by district administration and to submit the report thereof immediately. That on 30/06/2003, upon receiving of the authorities' direction from the district administration along with the police department, has visited the area Jetragri, Budugri, Darangri, and gathered information from the villagers and concerned Nokmas pertaining to the alleged red hole mining and illegal mining in the area. That on further inspecting suspected area to be illegal mining, nothing fresh or illegal coal mining is found in the said jurisdiction as alleged by the petitioner. Lastly, but not the least, above named petitioner, without any aware of the fact and without any proper investigation into the alleged mining, he misled the Honorable High Court of Meghalaya by reporting the information and attaching therewith false photograph of other area, thereby resulting dismay and cause irreparable damage to good reputation and image of the concerned citizen of the area. By doing such act, apparently showed his intention for attempting and trying to merge and tarnish the good image of the respective Akung Nokma, its resident area in particular, and South Garo Hills district as a whole. With the above fact, we fervently urge upon you to kindly inquire into aforesaid matter and register the case the above named person under appropriate section of law for the interest of justice, for which act of kindness and solicited on the matter we shall be highly appreciated. Now, Your Lordship,
you attached false photograph. You filed a wrong.
That is their allegation. See, I have made submission. I was informed by the competent authority, Joint Secretary of the Government Meghalaya. I was with the BP Kakati and the police, other police officers and some government officers. Even that I have enclosed. We went that, and the FIR is also stated that it is not.
Then what happened after filing of the FIR? Then
they registered the FIR. And then now the
what section?
506.
506. Threatening.
Defamation, not threatening. 500 lots. I'm so sorry. 500.
500 is punishment in 499. Basically, it's 499.
Now, it's also from the record, there's one Annexure 10, the one Nokma, Nokma of Utugri. He is admitting there is illegal coal mining because he has stated to the...
How this court will go into all those things?
Lordship, that is there, but that's why I'm saying that...
What is your ground of challenge?
My ground of challenge is this FIR is filed against the petitioner only to cover up their misdeed. Because there was illegal coal mining that was happening. The forced
how do you know there is illegal coal mining?
Because the inquiry officer, BP Kakati...
Have you enclosed the report of the Justice BP Kotaki Commission here to show that this illegal mining is going on there?
Of course, that it is in the court.
No, if you do not give, then how you will refute this very factual aspect of the FIR? Though we may not go into all those things, but then this court is asking you. What is your basis of saying that?
But the FIR himself, FIR also stated that FIR was Justice Kakati was appointed on the basis of the complaint filed by the petitioner. That is a wrong statement. Justice Kakati never been appointed, not because the petitioner has filed a complaint to the High Court. He never filed a complaint to the High Court.
So we just overlook that part. Which way it matters you?
Yes.
How Justice Kotaki was appointed.
That
doesn't
even
matter.
they are not aware of this.
Doesn't matter. Their plea is that the filing a false report, false information, supported by a false photograph, you have defined them.
Yes.
In fact, there is. Now tell us which Nokmas are appointed. This thing.
This is Nokma. We make a private respondent. They are the Nokma. There are third Nokma from Budugri.
But then.
Budugri says that there is illegal
your ground of challenge is what? Only that thing.
No, ground of challenge is that number one I have stated. Seriously, lost. I will. Ground of, page. Not 15. Page 12 to 13, 14. I will, Lordship. I have make a lot of grounds. Page 15, Lordship.
What are these copies of the order passed by the full bench? What bearing it has there?
No, because just want to bring to the knowledge of the court that this is
just to make your petition strong.
Yes, this is the post and concocted FIR. Later, notice maybe issue. Let them clarify.
No, we will not issue notice until unless you say that why court should quash it.
Lordship, this.
What are your grounds? Just tell us. Tell us your grounds.
First ground I have said has been filed.
Page 15.
That is in the private page 15.
Yes.
Respondent number 6 and 7 with a malified intention to harass and tarnish the image of the present petitioner. Second, you have stated the FIR on 6. It is totally false and incorrect.
Come to the third.
There is neither direction from the higher authorities, the authorities to district administration and to police department to visit and conduct a spot inquiry pertaining to the illegal mining and illegal transportation of coal in Chopot area, South Garo Hills, District Meghalaya. PIL number 2 of 2022, PIL number 8 of the 2022 pertaining to illegal coal mining and illegal transportation of coal.
These are all. I do not know what this.
My only contention
cannot be considered now. What disposal of PILF 2022 has with this?
No. My only contention is that this petitioner is only trying to help
trying to help and defaming somebody to different.
There is no defamation. That's why
I do not know the argument which you should be made. You are not making this.
Even the FIR seems to be filing on behalf of the government. This is not for the government. In fact, we have make an allegation even the malified action against the officer in charge itself. Then Nokma has admitted this particular officer in charge have mobilized.
What representation you filed to this thing?
The complaint petition is my complaint.
Where is that?
This one, page 47, Annexure 8. This is the petition which I have addressed to the.
What these photographs are?
This is the photograph which I have enclosed along with the petition of the. Along with the petition, I have enclosed with the petition. This is the photography of the illegal.
Can it be considered as evidence? Can it be considered as evidence by this court?
Because since there was that petition was.
That is your. Let us see what you say in your complaint.
Lordship, Invited reference subject stated, may I read your lordship that page 47, reference subject stated about the undersigned complaints with activities have the honor to state that despite of various direction by the full bench of the High Court of Meghalaya in PIL number 2 of 2022, illegal red hole mining or unscientific mining is going on without adhering to the Supreme Court order as well as against the various court order in PIL number 2 of 2022 of the High Court of Meghalaya. It is pertinent to mention herein that the various direction had been issued time and again against the state government of Meghalaya in PIL so by full bench of the High Court of Meghalaya to check and stop the rampant illegal unscientific mining or red hole mining in the entire state of Meghalaya. The undersigned beg to inform and bring to your notice that despite of various orders passed by the High Court of Meghalaya, the illegal and unscientific mining is taking place at Jetra village, Daringri village, Udugri village, and under Chopot area, South Goresh district, Meghalaya. Under the notes of district administration, it is further stated that the police department, district administration, and other concerned departments are not serious in complying with the direction of the High Court of Meghalaya, as the people had been witnessing such illegal mining taking place in the above mentioned villages, which clearly reflect that the government of Meghalaya is not serious in preventing the illegal mining and reluctant to comply with the direction of the Supreme Court. Supreme Court NGT at the various orders.
Now what happened now after registration?
After this one, there's Annexure 9. There Justice B.B. Kakadias went for the sport inquiry.
Okay, and then what is the report of that sport inquiry?
Sport inquiry was conducted. As per this one, it was on 13 July 2023. It is Annexure 9.
Page
51. Where I was the later joint secretary.
You were also there when?
Yes, I was there. I was with the PP Kakati and some other government officers.
Yes.
So and then also police also was there. So this is the notice. As per this notice, I have where this notice says that may I just read your lordship. Where notice. Whereas you have made a complaint to the Honorable Justice retired B.P. Kataki through Chief Secretary.
That is with regard to the notice of this.
Notice issue. Then notice and on that date, the date was peace on 13 July 2023.
And come to the FIR, you did not say why this FIR should be caused.
The FIR was my contents.
There is nothing to show that your complaint also was in.
Lordship.
Your complaint, whether it is correct or not, we do not know. There is nothing on record. These photographs, so we cannot take cognizance.
Yes, no, Lordship, my
you have made a complaint. We understand.
I have made a complaint.
Therefore, Justice Kotagi visited the place. But then, what is the finding?
Of course, that finding is with the court
without
because
without that finding, how we will say FIR is untrue?
That report is with
Mr. Khan, how can this case be registered? Can it be? This is expressly barred. Bhojan Lal, counsel for the petitioner has not raised this point in his petition nor is in argument.
Absolutely, Lordship. I was about to come to that part.
You must have noticed that. This court has
yes.
noticed it.
Yeah, absolutely.
Now, how can this case be registered and investigated by police? Non-cognizable offence.
Absolutely.
This is a total bar. How can it be?
Absolutely. That issue remains.
The problem is that you see the councils do not come up with this.
And Lordship,
it is only because the court has noticed it. Otherwise, the contention with Mr. Sangma, I was hearing because I thought that somewhere that way he may come and say that he has not spoken a single word.
Nothing, totally different.
But then you were there, so I do not know whether you'd be. One thing is the problem is that there are private respondents.
Absolutely.
So if we have to pass any order interfering with this thing, we have to, without giving the notice, we cannot do it.
We have to give notice.
If you use your good office, because this it is only under section 500.
500.
No other cognizable offence has been this thing. So that has to be treated as non-cognizable.
Non-cognizable.
Then in such a case, police cannot proceed.
Absolutely.
Without the order of the magistrate. That is what the law is.
He was not forwarding an argument in Lordship. Sometimes
this is not a court of this thing, but then it has come to the notice of the court.
And sometimes, Lordship, we can't have a carrying. In a matter like
this, no other option but to share with you.
Absolutely, Lordship is correct.
So if you use your office and advise the police accordingly, I do not know, but then this, otherwise it seems, until and unless we do not know whether there is a direction by the magistrate to do it or not.
We don't know. We don't know.
We do not know that. But then otherwise it seems it cannot be. It cannot stand. It has to be caused.
Absolutely. But Lordship, private respondents then without hearing them
we have
also.
to give them notice for these things.
At least give them a notice and let them.
Otherwise, he doesn't have a case.
Yes, no.
We cannot go by the fact whether it is correct or not correct and all
No,
this.
that part, Lordship, law is very
If
settled.
I once
Lordship
discloses
is very
something
settled.
that is...
Law is very settled.
The only
on that.
concern is that. And he has missed that main point. The main foundation of his case is missing.
And Lordship is aware when those things are absent from the pleading, sometimes we can't go into.
It is not there in pleading and he has not argued.
He's not argued. He chose not to argue.
This court was hearing him for so long for that.
Hoping that he'll come to that point.
Probably.
So Lordship, I still let notice. Oh.
Just see if you have these things, then we will not keep these matters pending for small issues and all. Why should we keep it?
Absolutely.
And allegations also is not that serious, you see.
It's just defamation, Lordship. And investigation by police to find out whether it was correct or not. And
You
then
have not prepared case. You do not know what your case is, which your case you will be successful. This sorry state of thing, Mr. Sangma. Only one submission, you could get this case FIR demolished. And you are missing that. Heard, Mr. P.T. Sangma, Higher Council appearing for the petitioner. Issue notice. See, officer in charge has been implicated as by name. So I don't think you will appear or...
No, I cannot appear. By name, I cannot appear. First thing, Lordship,
why you have implicated officer in charge by name?
Because of the Annex 10, the one that Nokman said that he has instructed.
Yes, Mr. Khan, you were saying something?
I said, Lordship, was there any requirement for alleging? Because there is no pleading of malafide against.
Yeah, pleaded. The pleading is this.
Since he has been implicated, let him come.
But let him take his notice.
If
and this is
unnecessary
Lordship, it's his case, so Lordship, let him take his
we
care.
penalize him.
Let him take care of his case.
Issue notice, returnable in 2 weeks or 3 weeks.
Garbo has Lordship, maybe 3 weeks. Garbo
3 weeks. Mr. K. Khan, learned AG appears.
1 to Lordship 1 to 3 only. We are for 1 to 3.
For response number 1 to 3. Stop. The petitioner shall take steps for service of notice upon response number 4, 5 and 6.
Lordship.
Within 2 days.
Lordship, within 2 days. Within 2 days means like tomorrow is holiday. I think only on the Monday or Tuesday only I can.
2 days means 2 official working.
Official, Lordship.
Monday, Tuesday.
Monday, Tuesday.
You are a lawyer, you know that very well, how we compute this.
Lordship.
List after 3 weeks.
Oblige.
Please see the cases. Please prepare. You see, if you do not do, then it becomes, like sometimes it happens like that. That the court knows that it's a good case for the petitioner. The lawyers, they do not place good points, and the court of its own cannot raise it.
Absolutely.
Normally, court would not like to dismiss a matter where petitioner has a case.
Absolutely, Lordship is correct.
That is what the problem is. And if it doesn't come from the mouth of the counsel or the petitioner,
And we also have,
then the respondents will come up with the allegation that court is siding with.
Lordship will never come out. Only thing is this, Lordship, we can't respond. If the ground is not raised,
that is that exactly.
There's a limitation in Lordship.
Exactly.
Otherwise, Lordship is aware that it's live streaming, hybrid mode, everything is open. So we also have to be very careful. Like if the case is not raised and we're trying to answer something which is not supposed to.
See, that part, non-cognizable offence, that is the only thing you have to counter.
Yes.
Otherwise, you may not go by what I have.
Absolutely. I'll take it. Oblige.
Item number 2.
Yes.
Lordship.
LC record is received.
LC record is to be called.
You prepare paper book?
No, Lordship, it is to be admitted now. It is for admission today.
Admit, is a paper has been admitted.
Last date only this has been condoned.
No. Admit this appeal, it's written.
He can file he can prepare the paperwork in that Lordship.
Who will prepare?
Registry will prepare.
You are legal aid counsel here?
Legal aid counsel.
The lower court record has been received. Stop. You stop. registry to prepare paper book and supply a copy of the same to the respective parties. This is matter after 4 weeks.
Hello. Mail list, item number 8.
Yes.
Oh, this is regarding recruitment, my lord, in the CRPF. Now, if I may go into the brief fact of the case, my lord.
Yes.
My lord, what had happened, my lord, that in the year 2015.
Anything you want to say?
Lordship, DSGI will be appearing, Lordship.
He's here. He is
Yes,
here.
Lordship,
He's okay. Court will wait for him. Yes, Mr.
So, my lord, the brief.
What is the challenge in the writ petition? What you are challenging in the writ petition?
My lord, here, my lord, what had happened? Because that is exactly why I have to go into the background of the case, my lord. So
No, you are challenging. What is the relief?
Here I am questioning my lord, the marks which have been allotted to me in the trade test, and the manner in which the trade test was conducted, my lord. I was denied a fair opportunity.
Allotted not tested during the course of selection process.
Yes, my lord. And the manner in which
can it be challenged?
My lord, yes, my lord. Because the manner in which it was conducted, my lord, I was denied a fair opportunity. It is against the norms of equity and justice, my lord. Now, why I will say that, my lord? So that is exactly why, my lord, I have to go into the background of the case. This is, in fact, this is a second round of litigation, my lord.
Yes.
So what had happened, my lord? there was an advertisement which was issued for recruitment in the CRPF, my lord, in the year 2015, my lord. Now, accordingly, my lord, I had given my application. Then, my lord, I have participated in the physical test. My lord, I qualified in the physical test. Then thereafter, my lord, on ground that I do not have a genuine domicile certificate, my lord, they rejected my application. So, subsequent...
After taking part in the selection process?
Yes, my lord. On the ground, physical test, I qualified, my lord. So, thereafter, my lord, they rejected my candidature on the ground that... And, my lord, in fact, the vacancy was around 49, if I'm not mistaken, my lord, 40 some posts, my lord.
What is the advertisement?
My lord, the advertisement is at...
After the advertisement, why should you give submission in an unsure way?
The advertisement is enclosed at, my lord, enclosed at annexure 3, my lord, page 18 of the writ petition.
Yes.
So, my lord will kindly see.
518 constable, technical and trades.
Yes, my lord, technical and trade.
You are fall to which category?
I am for the tradesman, my lord. So, under the tradesman, my lord, I had
Post of cook, my lord.
Given my application for post of cook, my lord. So, my lord, after qualifying in the physical test, my lord, what had happened? They rejected my application on the ground that my domicile certificate is not proper. It is fake. Subsequently, my lord, I filed a representation, but it did not.
Normally, what happens when you apply?
My lord,
the scrutineous document is taken up first.
My lord.
Thereafter, you are given a call.
My lord, but in this case, my lord, no such objections were raised. My lord will kindly.
No, that is what. See, kindly understand. My lord. It means the normal procedure is what? Once you respond to an advertisement and you apply, your application is scrutinized. And if it is found all right, then only you are called for selection test, isn't it?
Exactly.
So now here it's a case where after you have taken part in the physical test, they found that there is no domicile certificate.
Yes, ma'am.
So that decision was taken subsequently.
Subsequently.
Then what happened?
Then thereafter, my lord.
This requirement of domicile certificate was a condition put in that advertisement.
My lord, in the advertisement,
where advertisement says what? What are the requirement?
My
The
lord,
application was to be supported by what documents?
my lord, it is written in the next page, my lord.
Where?
My lord, how to apply, my lord. Eligible and interested candidates can send their applications.
That is with regard to the envelope and all those things.
Yes, my lord. Given, but normally what happens, my lord, in any armed forces recruitment, my lord, they, as to my knowledge, my lord, they do ask for domicile certificate, my lord.
No, what is the requirement? If you say, see, your knowledge is like, your knowledge must have been gathered from something, isn't it?
My lord.
From where you gathered that knowledge?
My lord, through our experience.
See, this helps your case.
My lord. So, my lord, if I am allowed to read what is written there, my lord. Eligible and interested candidates can send their applications in the
It
prescribed
doesn't
format.
speak about, you see.
May I clarify on this aspect? My lord?
Yes.
On the advertisement at page 18, Lords, you will see, my lord.
Yes.
Well, there is a symbol, my lord, on the left hand side.
Yes.
Just there, total number of vacancies 518.
Yes.
State-wise vacancy details.
Yes.
Arunachal Pradesh 17.
Meghalaya
Assam
49, yes.
Meghalaya 49.
Meghalaya 49.
Yes, my lord.
My lord, this is done to maintain some kind of proportionality between the states, my lord, because these are central forces. So
Representation of the state.
So Meghalaya was 49. So people from Meghalaya under this quota, they must produce the domicile of Meghalaya. My lord.
Yes.
That was the correct condition. My lord.
But however, of course, it's not shown in the advertisement. My lord.
So that means a person will have to first prove that he is a subject of the state from which he is.
But because he is claiming the, my lord, the quota from that state.
Achha, then anyway, then what happened? Then rejection. Then your candidature was rejected.
Subsequently, my lord, I approached this honorable court by filing a writ petition, my lord. Now, my lord, that writ petition, my lord, it was found after, my lord, after detailed hearing, my lord, and my lord, state was also made a party here. The office of the deputy, the issuing authority was also made a party here, my lord. They also approached before this honorable court and informed this honorable court that the domicile.
Why state was made a party?
My lord, because the domicile certificate is issued by the deputy commissioner, my lord.
So that was your case, that you tried to obtain domicile certificate and you did not get it.
No, my lord. Our case is that we had given our domicile certificate. The appointing authority said that your domicile certificate is not genuine. Now, my lord, to prove that my domicile certificate was genuine, my lord, I have also arrayed in the earlier round of litigation, the deputy commissioner was made a party. They also came before this honorable court and then they verified, my lord, that this certificate is genuine, my lord. Yes. Then thereafter, my lord, on the strength of this honorable court's order while disposing the matter, this honorable court directed that you please allow him to participate in the process. Please carry forward the process. So, my lord, after that, my lord, I was allowed to participate in the written examination and then subsequently I had to sit for the trade test, my lord. Now, my lord will kindly see the manner in which...
So, domicile certificate part is not an issue anymore?
No, my lord.
That part is over?
That part is over.
Okay.
So, this is the second round of litigation.
Yes.
So, what had happened, my lord, is that in fact, in my rejoinder, I have given in quite a bit of detail, my lord. My lord will kindly, if I am allowed to take my lord to my rejoinder, my lord.
Now, what happened when you took part in the selection process? Just tell us the fact.
Then again, I was made to sit for the test, my lord, written test. I qualified. Then subsequently, my physical test, written test, I qualified. Again, physical test, I had to go up, my lord. Thereafter, again, I sat for written examination. Then thereafter, my lord, on that very day, I was informed that I will have to sit for the trade test. Now, this is the manner, my lord. In fact, my lord, I had made an averment in my rejoinder also, my lord, that when I had pursuant to the order of this honorable court, my lord, when I had gone for the test, my lord.
What about other candidates?
My lord, I am the only person who was challenged it, my lord.
Watch, then what about the all other applicants?
My lord, out of 49 vacancies.
No. See, just let the court complete its question.
My lord.
Now, definitely it is a recruitment process.
My lord.
So, apart from you, there are many other candidates.
Yes, my lord.
So, they also took part in the selection process, isn't it?
Yes, my lord.
Now, the day on which you took part in the selection, whether selection for others were already over?
Over, my lord.
Now,
already over.
so far as their selection is concerned, it was held in which manner?
My lord, as usual, my lord.
What do you mean by as usual? This court doesn't know as usual. That should not be the reply. Just tell us how, whether these tests were conducted on the same day or
no,
on
no,
different.
They were conducted.
Who prepares the schedule?
My lord, of course, that answer, of course,
your case is founded on something.
My lord.
You want to say that you have been subjected to undergo all the tests in a single day.
Yes, my lord.
Okay, so that is something not correct, not legal to.
No, my lord, why I am saying so, my lord, even assuming a situation, my lord, that it is on the same day, my lord, the call letter itself ought to have, my lord, clearly mentioned that in the event you qualify the written test on such and such date, you shall have to sit for the you shall have to sit for the trade test.
Yes.
The call letter does not say so, my lord. My lord, if that is exactly why, my lord, I want to.
So you want to say that trade test was not a part of the selection?
Trade test is only subsequently, my lord. Only after I qualify in the written test, my lord.
So once you are asked to appear in the trade test, that means you qualify.
My lord will kindly, if that is exactly why, my lord, I want to take.
Just try to understand one thing, that the day on which you were examined, when your examination was taken,
my lord,
you were the only candidate.
Only candidate.
So there was no basically purpose of delaying it.
My lord, it could be otherwise, my lord. It could be with an intention to summarily, my lord.
Just because you say, that will not do. You see, that could be and should be, cannot be a basis of
my humble submission, my lord.
You just say that how that selection, holding of selection on one day has prejudiced you, or
yes,
it is against the norms. Don't say yes, you show us how.
My lord, how, my lord? Firstly, my lord.
That is why you see the initial query of the court is that so far as the other candidates are concerned, in which manner their selection process was held.
My lord, then for that, my lord, because there was paucity of time, my lord. Because, my lord, if I may.
Then how you will argue your case? On what basis?
Lord, if that is the case, I'll have to file an RTI, my lord.
That I do not know. That you prepare your case.
Because what had happened?
Which way you should do this thing? This court basically would definitely, to appreciate your submission, would need some materials to hold it, that the process which they have adopted was not correct in law.
My lord, if I may humbly submit, even for ends of justice, my lord. Now let us assume that I have qualified, just for instance, my lord, that I have qualified in the written test, my lord. So, my lord, next step naturally would have to be trade test, my lord. Now, when the day I went for the written test, my lord, I had no other certificate or document with me, because I was never asked to produce anything. Yes, my lord, that is exactly why, my lord, if I can kindly take my lord's attention to annexure 1 of my additional affidavit, sorry, my lord, my rejoinder, my lord. What the call letter says. Which is of my rejoinder affidavit, my lord, page 12.
The call letter which was issued after the first round of litigation.
Yes, my lord.
Was there any issuance of call letter before, when you took part and your candidature was rejected because of the domicile certificate?
Yes, my lord. I was informed, my lord.
It was informed. There was no issuance of call letter.
No, there was no issuance of call letter.
But then the second instance you had call letter.
Yes, my lord.
Where is the call letter?
My lord, it is at annexure 1, page 12, my lord, of the rejoinder affidavit, my lord. So, my lord, this is my again subsequent.
The court is yet to get. My lord, please. Page 12.
It is a small affidavit, my lord, short affidavit. It was filed on 31/5/23, my lord, if I am not mistaken.
It's a small affidavit.
My lord, it's a very.
I think it's at least 15 pages.
My lord, 12 pages. 13 pages, my lord.
13 pages. Yes.
So, my lord will kindly see. I had to sit for physical test again, my lord. Though I qualified in the physical test in the earlier round, my lord, But even in spite of that, I had still had to sit for physical
But
test.
you qualified. Second time also
I
you qualified.
Yes, madam.
No issue. Forget it.
If I'm allowed to read. Madam.
Yes.
You have successfully qualified the PET/PST examination for the post of Constable Cook conducted by the board officer at this group center on 30/11/2016. Hence, you are directed to report at Group Center CRPF, Katkati on 5/12/2016 at 9 hours for written examination. Duration of the examination will be 2 hours, that is 10 a.m. to 12 o'clock. You should bring this letter. So this is the criteria, my lord. You should bring this letter for appearing in the written examination at the recruitment center, that is Group Center CRPF, Katkati. That is it, my lord. It does not say that in the event you qualify in the written test, you will have to sit for the trade test, my lord. The call letter does not, there is no whisper, my lord. Now on the same day, my lord, I am handed the call letter for the written examination, my lord.
Where is that call letter?
That is a subsequent annexure, my lord, annexure 2, page 13.
You have successfully qualified.
It is to inform that you have successfully qualified in written examination for the post of Constable Cook conducted by the board officer at this group center on which date, my lord? 5/12/2016. Hence, you are directed to report at Group Center CRPF Katkati on 5/12/2016 at 15 hours for trade test.
In the same place?
In the same place.
You reported?
Same day. I was there that very day, my lord.
You reported?
Yes, my lord.
And then?
That is when, and then I sat for the trade test.
Then you appear set for the trade test?
Yes, my lord.
And then?
Then thereafter, my lord, they have, because I was not aware what was happening, so I had to file RTI.
Did you raise any objection? Did you file any protest letter?
My lord, of course, at that instance, I did not file. But my lord will kindly...
That is
my lord,
not the requirement. Now, just tell us
my lord,
how it happened for other candidates in the same recruitment process.
my lord, that information, of course, currently I don't have, my lord.
And is
I'll
there,
have to
see, trade
get
test
this information.
involves what? Trade test involves what?
My lord, trade test, suppose I am a cook, my lord. So, they will test my ability that whether I am able
asked to cook something and you have to cook.
My lord.
So, which way holding it on the same day prejudices you?
My lord, definitely, my lord, because they have also omitted my marks.
You are a qualified cook. It is not required that you have to go first prepare some recipe, then you have to come with that, and then you have to.
My lord will kindly see, my lord, in the test test certificate, if any. Nil. They have not. I have not been allotted any marks.
Tell us which way it has happened to the other candidate. So we can say that we are discriminated. We
My
can
lord,
say that other candidates have been given opportunity. You have not been given opportunity.
For that, my lord, I will have to.
No, but then that is
information.
the crux of the issue is.
Because my lord, even by any means, my lord, what to my understanding, my lord, what normally would have happened is that, my lord, trade test would have to be conducted on a separate day, my lord.
Why?
My lord, these are two different
If
tests.
this trade is dependent of procurement of some equipment, you see, then I can understand. Or it's a lengthy job. Okay.
No, if that is the case, my lord, then the call letter should have.
Mere cooking. You tell me I can go out and cook it nowadays.
Not
See?
that, my lord.
So I
But
don't
my
see-
lord, the call letter should have indicated that, my lord. That in the event there is no such condition. At least I would have
Okay,
prepared.
That was still the stage of holding written examination.
My lord.
Now on the same day they found you qualified. So for one candidate, why to keep this exercise pending? They thought let us finish
I
it.
could say that this was summarily just to, my lord, just
Which
to.
way you say? What can see? Your mayor saying will not do.
My lord.
You understand what law requires.
Yes, I
You need
understand.
to show that which way it is barred.
So, my lord, for
Just
that
tell
then
us
I'll.
that, then we will interfere.
Then for that, my lord, I'll require some time because
And
I'll
if you
have
can
to.
make instances, then if you say that for all other candidates, they have given time and all, though I don't think it would be necessary. It would be necessary.
But
If you are a cook, if you are a qualified cook, I don't think why you should have a.
According to me, my lord, if I respectfully submit, my lord, it would be necessary. Why, my lord? Because let's assume a situation that, my lord, there are, say, my lord, 20 people who have qualified on the same day in the written test. So, my lord, will it be possible for the department to hold trade test on the same day?
Difference. They appreciate it that you are the only candidate, and your examination was taken on the basis of the order by the court.
Nevertheless, my lord.
What is the question of comparing
my lord,
that situation?
but even assuming that, my lord, can I be denied a fair opportunity, my lord?
Which way it is unfair? Was it something like that? You were not provided with a gas stove or salt or with other ingredients for cooking?
My lord,
is it your case?
My lord, firstly, my lord will kindly see in the markings, my lord, they have omitted, my lord, they have given 0 marks on the fact that I do not have any certificate. Now, my lord, I have not carried, naturally, my lord, I have not carried any certificate on that day.
What certificate you had on that day, possessing on that day?
No certificate, my lord. I went.
Now, in your petition, what did you say? Which certificates you were having all those?
My lord, certificate.
Which certificate you could have produced?
Which is at annexure 9, my lord, page 41 of the writ petition. 41 of the writ petition, my lord.
Yes.
My lord, this is the certificate which is enclosed, my lord.
So you are only trained to cook chicken curry, egg curry and rice chapati?
My lord,
nothing else?
In fact, during the test, my lord, what had happened, I was...
For this, I don't think you need any expertise, isn't it?
So, my lord will kindly see, my lord.
Now, this is okay. Then,
and my lord, most important.
When your exam was held, when your exam, your examination took place
was on 5th itself, my lord.
Of 5th of?
My lord, it was 5/12/2016, my lord.
5/12/2016.
Yes.
Yes. And what about the other candidates? How it held?
My lord, of course, that information at this point I don't
have. It was a comparative thing. See, otherwise,
my lord, if my lord kindly allows me some time, then that way, my lord, I'll file an RTI and
these are the matters which are pending for quite some times, isn't it?
My lord,
see, 2017 and coming 2020.
My lord, may I kindly
was there an interim order to keep any post vacant and all those things? No. Was there?
My lord, that I'm.
Yes, Dr. Mojika, was there any interim order to? I don't think, my lord.
But my lord, they have also not stated in their affidavit that there is no vacancy, my lord. That also they have not refuted, my lord.
That vacancy means?
My lord, it is not a case also that the government has.
No, what is the situation now? You see, how do you expect that? You say like some favorable order will be passed.
My lord, in the earlier
even
round,
if you can make out a case.
My lord, in the earlier round, my lord, I have continued participation in the same selection process on the strength of this honorable court's order, my lord. It's a question of one post, my lord. So, my lord, this honorable court can definitely issue a direction, my lord.
My lord, one important aspect, my lord.
Yes.
My lord, the last date for submission of application in the advertisement was, my lord, 20th of December 2014, my lord. Along with his application, he never submitted this experience certificate, so-called experience certificate, my lord.
Now, this certificate was
certificate is dated.
Let us show us the marks thing. Were very short.
The certificate is certificate is of 2015, my lord. This certificate is of 2015, my lord. The last date was 2014, my lord.
No, my lord. The scrutiny authority never objected. My lord will kindly see. I was rejected on domicile.
That is what we would like to see when those certificates were required to be submitted.
My lord,
whether that was to be carried along with the candidates while appearing for the test.
My lord,
where you
this submission itself, my lord, any certificate, whatever my experience or knowledge, my lord, that application I have to submit along with my application.
Please wait.
That
you will have your chance.
That I have to submit along with my application. The last date for submission of application was 20 December 2014, my lord. Lordship will see the date of certificate itself, my lord.
Yes, this is all right. It's 2015. Now, if that be the thing, my lord, did you reject his candidature?
No.
For want of that certificate?
My lord, it is not. We are not required. We are not required to reject, my lord.
Why?
It is not mandatory to annex a certificate of experience.
So then that means like
he'll get extra marks if he annexes a certificate, my lord.
Okay.
So he got 0 for certificate, my lord.
Not carrying extra marks.
For
not carrying.
Not annexing.
Now
the
that is what. See, whether that certificate was required to be carried at the time of appearing in the test.
No, my lord.
Or whether that was to be submitted at the time of applying.
Along with the application, my lord.
How do you say? On what basis you say?
My lord, any certificate we annex at the time of application, my lord.
That is to fulfill your eligibility criteria. Now you say that this has nothing to do with eligibility criteria. It is only for the purpose of, like getting extra marks.
My lord.
Then? Now,
any application complete in all respect, my lord, must be submitted by 20 December 2014.
See, that is what we see. Once you accept this candidature, all those other aspects are fulfilled.
Well,
now, if you say that the certificate was only for the purpose of, like awarding some extra marks, in such a case, we would like to know that when the certificate was needed to be produced. If it has nothing to do with these things.
In my humble submission, whatever certificate somebody wants to produce, my lord, he has to submit along with the application, my lord.
Now,
after the process is started, in my humble submission, there cannot be any opportunity for submit additional documents, my lord.
Now, you see, there are certain things. You see, like when you have the test, where you see, like it is held in, say, 2 parts or 3 parts. You see, candidates carry certificates, and on that basis, then we would like to know that what is the scheme of the examination also. What would entitle a person to be awarded to extra marks, to some extra marks?
And my lord, that mark, if I may respectfully submit, my lord, is included in the trade test, not in any other. So how can it be, my lord?
The court did not get what you are trying to say.
My lord, the certificate, the point of certificate, my lord, is included in the trademark, my lord.
See,
it is in the trade.
So far as the criteria for selection is concerned, okay, what should be awarded, what should not be awarded, that is totally their discretion.
But my lord, the application doesn't.
It is not your case that scheme of the exam was one thing, and they have conducted in other way. So far as you are concerned, that is not your case.
No.
At least your petition doesn't say so.
No, my lord.
Then
my case is that I was denied a fair opportunity, my lord.
That is what. What do you say? Fair opportunity?
My lord, summarily, just to get it, my lord.
If you say that subjecting you,
yes,
to undergo test, trade test on the same day,
yes,
this court will never say that is denial, because so for trade test, so far as your expertise is concerned, nothing, you can never be prejudiced by that. Okay. Now, but then if you can show that yes, for other candidates, there are some, you see, like creation of extra opportunity or extra privilege, then definitely in such a case you will hold it. But then you are not in a position to tell it.
My lord, for that, my lord, I'll humbly pray that I'll.
And what is the basis of awarding marks? That also would be important.
So, my lord, for that, my lord, I'll require some time, my lord. I'll have to file
cases pending for 2017.
My lord will kindly appreciate, my lord, I have taken this.
What is the use of, you see, like hearing these matters in piecemeal?
My lord will kindly appreciate, my lord. I have taken this case only this year, my lord, couple of months back. It was earlier handled by a different counsel, my lord.
So it means your petitioner is not interested.
My lord, the petitioner
was
interested, my lord.
Dr. Mojika.
My lord, in para 8, we have responded to that, my lord. Para 8 of
in your affidavit.
My lord.
What do you say?
I just read, my lord. Para 8.
Yes.
That the averment made in para 10 of the writ petition is denied by the answering respondents. It is categorically stated herein that at the time of applying for the position as well as the trade test, the petitioner has not produced any certificate in the para under reply. And as an afterthought, the petitioner has now annexed some document to create a misconception about his cooking skill. The very date of the said certificate would itself establish that the said certificate has been obtained after the last date of submitting application was over.
And what is his reply to this in rejoinder?
Yes, I have replied.
The practical knowledge skill test was conducted in fair manner in which the petitioner was given opportunity to cook, but unfortunately he miserably failed to show his experience and the skill to cook. Trade test for assessment of objective and subjective knowledge was also conducted, out of which 50 marks for practical trade test. A candidate must secure 20 marks to qualify. The petitioner scored only 14 marks in the trade test and thus was declared failed by detailed board of officers. And that has been annexed at page 62.
Yes. It is also included in.
And what is your reply to this?
My lord, I have replied, my lord.
You have replied. What is your reply? Just say.
My lord, my lord, this is regarding 8, my lord, para 8.
Yes.
My lord,
Come to your page 5 of your rejoinder. Bottom.
Yes, my lord. That with regard to the averments made in para 8 of the affidavit in opposition, the answering deponent, while denying the contentions of the respondent as false and baseless, states that there was no criteria mentioned in the advertisement. Annexure 3, page 18 of the writ petition. The contents of the relevant portion are produced here. CRPF recruitment 2015, Northeastern Zone for 518 Constable, Tech and Trade vacancies.
what you
Technical
say?
qualification, tradesman. Boggler, trailer, so-and-so, cook, water, carrier, safai, karamchari. Now, what it says, my lord? Candidates must have good working knowledge in respective trades. Hence, it can be clearly seen that the said advertisement nowhere mentioned about the trade professional certificate. According to the said advertisement, the candidates must have good working knowledge in respective trades, and hence there is clearly no stipulation whatsoever for production submission of experience certificate along with the application. Needless to say that the application of the petitioner was duly accepted by the concerned authorities. There is no remark from any corner whatsoever stating that the application of the petitioner is rejected for want of trade certificate.
That is what the court has already
Yes,
put
therefore
on
the
the
allegation of the respondent authority stating that the petitioner failed to submit any trade experience certificate at the time of applying for the said position is false, baseless and contrary to the said advertisement, and the same is only an afterthought.
Now tell us one thing.
My lord.
Can a selection process,
my lord,
be dependent on the qualification to be acquired by the candidate post advertisement? What Dr. Majika has pointed out.
My lord.
This advertisement is of 2014.
My lord.
Now, whatever the requisite qualification expertise,
my lord,
that you should have on the day of the advertisement. You see?
My lord.
Now, if that be the thing and you obtain a certificate subsequent, that will not have any value.
My lord, even if that is so, my lord, again I'll go back to the advertisement, my lord. The advertisement does not specifically say that you have to have a certificate, my lord. It says
that
you
is a
have
common
to,
sense. That is a common
you
sense.
have to have a good working knowledge.
It's a common sense.
And my lord will kindly see, because my
see, we are not talking about certificate. The certificate basically shows what you are capable of.
My lord.
Isn't it?
Yes.
It's basically an acknowledgement of the quality or merits which you have.
Exactly, my lord.
Isn't it? So supposing if that is to be taken that way, say like that your ability or your expertise, that has to be there on the day when advertisement was made. Okay. Now, process cannot be dependent of the the post qualification which you acquire later.
My lord, if I may respectfully submit, my lord. Now let's assume a situation.
Say, supposing if you are given this advantage, then this will prejudice the other candidates.
My lord, in my respect,
and in such a case, if your prayer is to be entertained, then many other rejected candidates will come and they will say,
no, my lord, they have not come. My lord, I understand.
They will say, kindly, you do not allow the court to complete.
My lord, apologize, my lord.
Now, this will create a cause of action for the others. Many others will say, yes, we also could have obtained some certificate after the last date of this thing, submission of the application, as in your cases.
My lord, in my respectful submission, that will not arise, my lord.
Why?
My lord, the selection process is long over, my lord. My lord,
It's long
out
over
of
for
the
you.
49, my lord, if I may kindly submit, my lord, out of the 49 candidates, 49 seats from Meghalaya, I was informed that, my lord, perhaps only 3 seats were occupied, my lord. Most of the candidature has
Just
been rejected.
because there remains a vacancy would not make you qualified. First, you have to come through that test. You have to that test.
My lord,
First, you see, satisfy that you are a qualified candidate, you are a rightful candidate. Then only the question of existence of vacancy.
My lord, here another aspect.
So long you do not prove it, we will not go into that question.
My lord,
whether
another
there are
aspect, my
vacancies.
lord, here we have what we have stated in the writ petition, my lord, that the authorities have taken it out on us, my lord, they are already, my lord, not happy with us, with me, my lord, and therefore, my lord, that biasness is already there, my lord, because I had challenged their earlier
biasness
order.
is there. They could have rejected you in physical test. They could have rejected you in your written examination. But that is not the case. See, we can understand. There may be many things. It may be a case of definitely rejection because they do not like you.
My lord.
But then in law, you have to prove it.
My lord,
See, your mere statement will not do.
My lord, another averment which I made in the rejoinder affidavit, my lord, is that when I initially went for the test, my lord, the authorities there, my lord, they verbally told me, which is there in my averment in the rejoinder, my lord, that do whatever.
Allegation in rejoinder, which is not replied by them.
Yes, my lord, they do whatever you want.
Wait,
you
do
will
they
not
have the
get the
opportunity
job.
to reject it?
My
You
lord?
see, in every your reaction to every query is something. You have laid some contention.
My lord.
There is some new contention in rejoinder. Where is the opportunity for them to deny it?
So, my lord, they could have replied to my
No.
rejoinder, my lord.
Where is the law? Can you go on filing affidavit?
Only on that
And you
aspect,
will
my
bring
lord.
something and then can it be?
No, my lord,
Even just remember, filing of rejoinder is also not your right. It is only required only some points to be clarified, nothing else.
My lord, in fact, earlier there was no rejoinder filed. So, my lord, when I took up the matter, my lord, then I thought it necessary. My lord, and
No, you have
accordingly.
raised a contention in rejoinder which they have not replied.
Yes, my lord.
Then they did not have the opportunity to reply it. It cannot go on indefinitely like that. Then they will reply, then they will bring
lord is
something,
also well
then again
aware.
you will reply. As it is happening here and the case file is becoming this thick.
My lord, respectfully submit, my lord is also aware, my lord, that in certain recruitment process, my lord, sometimes the authorities have a high-handedness, my lord. That also, my lord is aware.
Prove it, you prove it.
So, my lord, for that,
You prove it. You see, like you just cannot even, you see, like project a case, how you are discriminated. How other candidates are selected. What is the basis of awarding marks? Nothing has been divulged in your writ petition, nor in your submission. Which way you expect this court will interfere?
My lord, I may be allowed some time because I will have to file an RTA, my lord. RTA application obtains certain information, my lord.
That you do in a way, say like this court will not keep this writ petition pending for, you say, like yourself to obtain RTA application. No. This is something too much. You should prepare your case before you file it.
My lord, this case was not filed by
It
me.
is something like, you see, procuring that certificate after this election.
My lord, this.
My lord, I have come. Hearing has been done.
My
So
lord,
now I do not have the point, so please allow me to.
My lord will kindly appreciate, my lord. This writ petition was not filed by me.
No, Mr. Bhattacharya, see, this is not the way to take up an argument.
My lord, rejoinder, I have given a very detailed rejoinder, my lord.
We have seen that.
My lord.
You have taken us to that.
Rejoinder,
My lord, in our affidavit we have annexed, it is written, when the written test was taken, my lord, how to cook chicken for 100 persons, my lord. His answer script
You
is
have seen his egg curry, this thing, egg curry, chicken curry and chapati. Now that is the expertise he had.
So my lord will kindly see that I may know, but I may not be articulate in explaining. My lord, if I am to explain that how to make a chicken curry, I may not be articulate enough, my lord. But that does not mean that I do not know.
No, then what way you'd be?
My lord, in the trade test,
just because you say.
No,
See,
my
this
lord.
is not the way to
My
argue.
lord, in the
things.
trade test,
If
my
you
lord,
are,
my lord will kindly appreciate. In the trade test, I was not asked to prepare chicken curry, my lord. I was asked to prepare vegetable that I prepared, my lord. And the officers also had, my lord. I also had, my lord.
no, you found it very tasty, and they did
My
not
lord,
find
it was
it
okay,
tasty.
my lord. But there is no whisper about what I cooked, my lord.
There are certain areas I don't think, you see, like this court can go and determine anything. The trade test and all, the awarding of mark and all, until and unless you see something which the law or the procedure provides, and that is violated. Otherwise not. And you cannot make out a case, even you have not brought any instance of any other candidate who are more or less, you see, like in a similar situation, has been given this much marks. A person carrying certificate was given award mark. Project us to those things, then we will definitely interfere.
My lord, I'll pray for some time, my lord.
But if I may just read page 14, my lord, in the affidavit.
That also I have explained, my lord.
Page 14 of my affidavit, my lord.
That also I have explained in my rejoinder, my lord.
Let him read. Why you want to reply before the thing?
My lord.
Page 14. That is a handwritten.
It's a handwritten, my lord.
Yes. Written skill.
Test written skill, my lord.
Yes.
The question time was 20 minutes, my lord. The question was how to prepare chicken curry for 100 men and write ingredients. He writes, my lord. Firstly, I have to clean the chicken meat nicely with warm water, and then cut the chicken into the piece so it can easily being consumed. Then it should be fried in the mustard oil and mix the species and spices in it for the taste in it, and cook till it should be cooked nicely. 20 kg of meat is cooked for 100 men. The ingredients should include curries. In curry should be chicken garam masala, salt for taste with tejpata, mix in the curry for extra taste in it. It should be cooked till it is ready for the meal. Onions should be fried when we start to cook for the chicken curry.
So you have given him 2 marks out of 5. And then declared him qualified in the written.
My lord.
Well, but then I don't think you also have any knowledge how chicken curry is prepared, Mr.
Personally, I don't have, my lord.
So,
but if I can compare it to the vegetable, my lord, I should say that how much.
Anything, this court. Yeah, expert. This is. The way you narrated the preparation of chicken curry.
Only with garam masala and salt you can.
I may not have.
Say, a person acquired 2 marks out of 5. That means 40%. Now, was there any criteria? Anyway, since you have declared him, you may not declared him qualified, so you may not go into that arena. But then here it seems they have given you this thing. They have favored you. They have allowed you to go to the trade test. They did not. They could have rejected probably on the basis of this.
So they completed the process.
If I was there, I would have given you 0. Believe.
My lord, but my lord, what happens, my lord? Sometimes we are not articulate enough to explain, my lord. May not be our English is not proper.
This is a test. Okay, so this kind of excuses.
So that is exactly why,
like this cannot be an argument also. I do not know.
My lord, that is exactly why fair opportunity should have been given.
Mr. Bhattacharya, which you are. That cannot be an argument. Sometimes you are not articulate. You are appearing in written test.
No fair opportunity provided. That day itself I am asked you.
For writing?
Yes, my lord.
For writing also no fair opportunity was afforded.
My lord, I'll have to prepare.
You are telling all these things before the court. Have you filed any representation? Let us become now. We will be very technical now. Have you filed any objection? Have you lodged any objection with regard to the mode and manner of conducting test? Show us. Let us see what is the rejection. Have you addressed to any higher ups?
No.
Then? Argue like a lawyer. Establish your right, take the case. This is not the way you appear in a written examination, and sometimes I may not be articulate. I may know many things. It may happen I am also very knowledgeable, but then I cannot disclose it. Then what knowledge my purpose serves?
Lord,
that cannot be the basis you argue in a court.
What I respectfully submit, my lord, if an opportunity was given, now my lord, if a separate date for trade test was given, I would have mentally prepared. My lord, I would have.
Now, say if it is given, if it had been given after 3 days, you would have been more prepared. If it is after 3 months, you could have been an expert cook by then. Isn't it?
My lord, at least
if that is the basis of argument. Now, just to say that, right from the beginning, court is saying, just show us which way other candidates were treated.
That is exactly why, my lord, I have sought
and
for
what is
time
the schedule of, you see, like exams prepared? That physical test on such and such day, written test on such and such day, trade test on such and such day. Show us all those things. In absence of that. But then one thing you please bear into your mind. That you are a single candidate when you were made to appear in the test. Okay. So I don't think there was any need for all those things until and unless a schedule is prepared in such a way that you are highly prejudiced. You are a cook. The quality is carried with you. And it is not a case that they have asked you to cook without providing you utensils. All these things were there.
Oh, that is.
Then? You are a lawyer, you know how you can establish a case. You just cannot go to a court and just say that, you see, like, I'm very much able and all, but then since I could not argue a case, I have lost it. So that becomes a ground for interference appeal. Can it be?
No, that is not the case, my lord.
Your submission is in that line only.
My lord, I am basing it, my lord, on the certain facts, my lord.
That is okay. Okay. Now, if these facts we take into consideration, so far as this court is concerned, okay, find that no case has been made out. Because you see, like for cooking, normally in normal sense, you do not have to carry along with you your own spices and all those things. You are provided the ingredients there, you cook it there. You just see the exhibition of your quality. Now, even then, since you have raised this, we would like to see how the other candidates were treated.
My lord.
And that, so far as the certificate part is concerned, you show us that there are any other candidates who were given marks for those on the day of which they carried. Your certificates apparently, after the last date of this thing as pointed out by the...
So, my lord, even assuming that my certificate goes, my lord, even then, because the advertisement does not say, my lord, that advertisement does not say that you require to submit certificate.
Yes.
Neither was my candidate.
You show us that the marks was given to some candidate for certificate which they were carrying on that particular day. Project it to us. We will interfere in that situation. Otherwise, we cannot make out a case of discrimination.
Certificate.
By normal sense, you have acquired that certificate, you obtained the certificate after the last date of the advertisement, submission of the application.
Yes, so certificate is only a component of 3 marks only, my lord. Even if you give him 3 full marks, my lord, for certificate, then also he is disqualified.
But then these are all points of his argument, my lord. He desires to accept his version without any supporting proof. That is what the problem is.
So, my lord,
there are no pleadings also. Pleading is only malafide has been alleged, my lord.
Kindly appreciate this writ petition was not filed by me. I cannot improve on what unless I
can be a ground.
No, my lord.
See,
but I have taken
Mr. Bhattacharyya, right from beginning saying that you are appearing as a lawyer and you have quite you say like a good experience. It is not the new counsel. Can it become a ground for the court to enter?
No, my lord. That
even if you assume, see, you are saying it correctly. We can understand. But then can it be a ground? Can this court pass any order basing on that?
So I'll pray for some time, my lord, in this case.
Yes, Dr. Majika, what to do?
In my humble submission, my lord, more it is delayed, sir, 2015 recruitment.
My lord, will kindly see the order sheet, how many adjournments I have taken, my lord.
Now, he has entered appearance recently, he says. He has not prepared the case.
I think even that is more than...
Right from the beginning. Sympathy cannot be a ground for interference. In my personal level, I can do it for you.
So, my lord, that is exactly right. My lord, I am praying I may be allowed to file necessary applications, RTI, I'll file, my lord, I'll get certain information.
That is for your liberty, which you do it. The next time when it comes for hearing, you just project as a case. You can make it as a case, we will interfere. If you cannot, then we will reject it.
Since March, Mr. Bhattacharyya is there, my lord.
My lord, I have filed my...
Earlier, Mr. Guru was there.
My lord will kindly see the order sheet, how many adjournments I have taken, my lord. My lord will kindly see.
It is your appointment. Concern should be yours, not theirs.
My lord.
They may take adjournment for 10 years also. If you do not oppose it.
So, my lord, I'll require some time, my lord, to get these clarifications.
Heard the learned counsel for the parties at some length. During the course of hearing, Mr. K.P. Bhattacharya, learned counsel appearing for the petitioner submits that he needs some more time to prepare the matter. The prayer has not been objected by Dr. Majika. Stop. Accordingly, this is matter after?
I'll pray for 4 weeks, my lord, because I'll file an RTI, my lord.
See, if you are eager, just...
My lord, because unless I have RTI information, my lord,
so then your case will be rejected. This court cannot give you indulgence for preparing. It's 2017 case. We do not go by which lawyer was appearing. Now, if you say your RTI will have a 30 days time. If it is rejected, then your appeal will have another how many times? So that on that basis will be adjourned.
I hope it will not be rejected.
Your hope doesn't work. See, basing on your hope, we cannot work. Your pattern of submission is something. Your hope, your expectation, your ability. List after 3 weeks. Have 3 weeks. Please come prepared if you, whether you obtain RTI or not, then next time please. These I don't think these are very big issues for which these cases should remain pending for 6-7 years.
17.
Right.
My lord, this matter in the last occasion, if I recollect properly, on 28 August, I made a thorough argument, and after my argument, there was a point where
this is not land acquisition, no? Is it?
Not land acquisition. It regards to the termination of the assistant professor by the managing committee or the governing body of the Women College.
You will have to refresh us thing. Mr. Shen, you are there.
I'm referring to the university. On the last occasion, my lord, sorry, I was not here. Last occasion, after the course of hearing, Lordship had a query whether the university has recognized that particular department was affiliated to the university. So I have obtained those instructions.
And the second instructions that the Lordship required from my friend from the college is that in the affidavit, they state that they have offered a full-time post for class 11 and 12. And therefore, in view of that, Lordship directed him to take instructions as to how many vacancies are available, sanction posts available. And subsequently, he informed that there is no sanction post, there is no more vacancy. But it is not clear, my lord, whether how many sanction posts are there and all sanction posts are filled up, or only temporary teachers are occupying or not. So that is not clear. That is not clear. Now, for today, my lord, for my prayer, my lord, before I proceed, if Lordship permits, according to me, to assist my lord, 2 records are necessary, because the impost normally grant recognition for class 11 and 12 when the school fulfills the essential criteria for sanction posts are there, infrastructures are fulfilled. My lord, that is required. Now, in this case, we are not clear, my lord. The instruction is not clear. Therefore, records, if Lordship direct the government respondent imposed to produce the records relating to recognition and the sanction teachers of the Women College, class 11 and 12. And second one,
record will be there with the government, or it will be with
Impose is a party.
But then Impose is a party. Who is representing Impose? Impose is not government.
I think my friend cover appears, my lord. State is a party and
Impose is a separate entity.
We have taken steps. I think the notice I received by the state, I think, long ago.
Who entered a case?
Respondent number 7, my lord, is Impose.
Who appeared for us? Number 7?
My lord, the order sheets, previous order sheets, my colleague find out. My friend is trying to find out, my lord.
My lord, in one occasion, my lord, respondent number 7 is
Mr. Abraham represented. 1, 2, and 7.
He appeared, and subsequently now my friend Mr. Patacharji is there.
Then 7, he appeared on behalf of number 7 also.
And second,
I don't think government advocates are representing Impose. They have. Yeah, KP Patacharji, GA for 1, 2, and 7.
Yes. So that means he appeared.
But they are all public parties.
Impose. Do not have. Are you sure?
Yes, but they cannot have
It reflects that my friend represents.
No, if you say you will present, there will be no problem. But then you should be sure of the fact. You see.
Yes. Well, since my friend is appearing for number 7, my lord, according to me, that record is important. And secondly, would also
record pertaining to what you said.
Pertaining to my
see,
lord.
Sangresh, I'm sorry. This court has forgotten the fact of the case.
Well,
Only what it remembers that they are basically a kind of proposal by the court that whether respondent can accommodate you or not. Instruction was obtained and then learned counsel placed before the court their inability.
Yes.
So that is what.
No vacancy.
But then
so
they forgotten the other parts.
Therefore, to ascertain that position, record is necessary.
What position?
My lord, to ascertain as to whether, my lord, how many sanction posts, so sanctioned teachers are there for class.
So far as this particular institution is concerned.
Yes, particularly this institution.
To that effect,
they can give the information.
My lord, to that effect, my lord, the petitioner, my lord, was appointed in college sanctioned post, my lord, when the higher secondary and the college was together, my lord. So, my lord, it is governed by the management committee.
Higher secondary and college was together.
Together, my lord. Together.
And he was working there in the college.
It is higher secondary section, my lord.
But what happened in this case? When I was appointed in 2011, there was no segregation, but class 11 and degree are one. Same management. My lord.
It was together, my lord.
Therefore, my initial appointment was as a
lecturer.
lecturer.
School had one management for all the classes.
For all the classes.
And school had the classes up till class 12.
Class 11 and 12. Now, my initial appointment is for class 11 and 12. They do admit it in the affidavit.
Yes.
And now, in the meantime, I was also allowed to teach for degree level.
When this degree level was introduced?
2018. Now, thereafter...
You served in that from when?
From 2011, and I was regularized in 2013.
There is
And
no
during
regularization.
Anyway, this period of time, let us just recollect. Mr. Chandu, we have forgotten, the court has forgotten the things. Just to, first gather idea of what the matter was.
But therefore, later on, there was a segregation. Class 11 and 12 were taken out and supposed to manage separately and degree level separately. Now, during that time also, I was allowed to teach the degree level as an assistant professor. That was continued in 2019. They took a decision.
When you were inducted into the service of the institution, the institution had the classes up to graduation level.
Yes, combined. Class 11 and 12.
But then it was all under one management.
One management.
Now, thereafter, the management of class 11 and 12 has been segregated.
Segregated.
Taken out.
Taken out.
So other, from class, whatever the starting class, 1 to 10 and the graduation, remained with another management.
After segregation, class 11 and 12, separate set of teachers are supposed to teach there. And now, since they don't have a separate teacher, the college lecturers, including me and others, were also allowed to teach class 11 and 12. Apart from teaching...
Is it stopgap arrangement?
Somehow, some stopgap arrangement.
Is it stopgap? You just tell your version. There is no problem. You just, right now, just do not bother about the legality. Just give me the facts.
The facts I'm trying to place. Perhaps it is stopgap arrangement. So all the college degree lecturers are allowed to teach in the class 11 and 12, and they give some remuneration, including me. And I was also allowed to teach for the degree level.
No, yourself you used to teach in degree level. Even after segregation also, you were to take classes in 11 and 12 also.
Yes.
In addition to?
Yes, in addition to degree level. So therefore, my initial appointment is for class 11 and 12. And I was allowed to teach. Yes.
You took classes in graduation also.
Yes. When I was appointed in 2011, I was allowed to teach class 11 and 12. That was the purpose.
Only class 11 and 12?
Class 11 and 12. But that time, there was a combined class 12 and degree. And later on, in that process, before segregation, I was also allowed to teach the degree level. So now I teach to class 11 and 12 and degree level. Now, subsequently, segregation came. After segregation, my lord, I was also allowed to teach class 11 and 12, apart from teaching the degree level. So other degree teachers also allowed to teach the class 11.
Though you belong to two different management?
Yes. No, it was the same management only, my lord. Even segregation comes, my lord. Same management continue.
Then how segregation? Then what is segregation?
There was the report will show.
My lord, the instruction imposed.
Let me just conclude, my friend. The management will clarify that one. There was no separate headmaster or the principal for class 11 and 12. They appointed one so-called administrator. Look after the class 11 and 12. But this administrator is under the umbrella control of the college administration. Well, now that was continued. And I was given the post of the regularization was given 2013 and 2018 or so. My designation was upgraded from lecturer to assistant professor under the UGC guidelines. Now, continue to teach in 2019. They said, your service is not required, no show cause notice, because from the beginning, there is no computer application department in the university, in the college. That was the claim. Now, I have filed a detailed affidavit, including the rejoinder. The college itself has furnished the details of the departments hosted by this college to the Human Resource Ministry. And in that, my lord, National Aggregation and Assessment Council.
Now you are pleading your case. Just give us the facts. You see, like you are, of course, getting to the merits of your claim. Now, thing is that you want to say that though there apparently seems to be segregation, but then there was no real segregation.
Yes.
Because the management of class 11, 12 remain under the umbrella of the management of
college.
This graduation or college.
Right.
What do you call it? And then the teachers were imparting studies, education in both sections. So there was no segregation. Now 2019, they said that your service is no more required.
Yes.
And your service it was in the computer cell.
Yes, computer application.
Yes.
Yes.
And they say like your service was for.
Now they say in that stage, Lordship has reached that stage. In that stage, they say that your service is not required because there is no computer application department in the degree level.
Where appointment was for 11 and 12.
11 and 12.
Even from the beginning.
From the beginning.
Yes.
And therefore, in the paragraph, in one of the paragraph in the affidavit, they say that therefore, they offer me a full-time scale of appointment for class 11 and 12, knowing that I was appointed for that purpose initially. And they say that I deny it. So I did not receive those offer. Therefore, Lordship.
So it is not a case of your denial.
Yes. So Lordship therefore directed him to obtain instructions. And since
because that, so far as this court recollects now, there was basically this learned council was saying that they are open to offer you the employment at that point of time also.
Right.
So on that situation, the court deemed it preferred
to
this thing. You see.
Correct.
Subsequently, he came with the instruction that no, you cannot be accommodated.
Yes. That is the instruction he received. And now that is with regard to class 11 and 12.
What role this university is to play here?
Now, university, my lord, in the degree level, though the computer application is not one of the recognized department by the university, but the college itself is under the, my lord, affiliation of the university. Therefore, we implemented the university as a pro forma respondent. We are not seeking any relief against the university.
But then what role they have to play? Like even if they say you include them in pro forma this thing, just because that computer section has been this thing.
My lord, in fact, there was a proposal for recognition of the computer application in 2007. Offer was given by the college, requested the university.
Degree section is affiliated to university. Isn't it? Degree section is affiliated to university.
Yes.
And the 12 is board.
Board.
Two different. Okay. Now, you will be concerned by which thing?
No.
Who will be your authority?
My authority is the degree level.
So then why you are asking for record by the board?
Now, therefore, my primary prayer is for degree level. But when discussion argument reached that stage, and I am looking for a job, therefore, Lordship, seeing the affidavit of the
alternative.
Yes. Seeing the government.
So you are looking for an opportunity. Now, yes, why you? If initially you have offered him some job, though he might have declined, why you do not accommodate him now?
My lord, we have informed him, my lord, that he can take the services at the HS section, my lord, with the new terms and conditions, my lord. But he did not accept it, my lord. The petitioner did not accept. In fact, my lord, he insisted.
That point of time.
My lord, in fact, he insisted that
But then
what
now
my
I
learned
think-
senior had, my lord, just submitted right now, that he is concerned with the degree level, my lord. But my lord, at this stage, my lord, there is no, my lord, department in the degree level, my lord.
Degree level.
My lord.
Now, what about higher secondary level?
Higher secondary, my lord, it is there, my lord, and
But then you will not accept it.
Now, higher secondary computer application
Because
is
it was,
there.
my lord.
And degree level also, my lord, computer application is there.
Now, which way it materially affects you?
My lord. Therefore, my prayer, first prayer is...
Yeah, so far as your career is concerned,
Yes.
service in the degree section and service in the higher secondary section, which way materially affects you?
My lord. My prayer is for the degree level.
No,
And
just
if
this
lordship-
court basically would like to know these two appointment or serving in these two posts, two different posts, one in the higher secondary section and the degree section. What is the differences? Which way it materially affects your service career?
My lord, the pay scale is completely different, my lord. The pay scale is completely different.
Okay, pay scale is different.
My lord.
Okay.
Yes.
And then your future prospect, everything will be different.
My lord.
But then your initial appointment was for the higher secondary section.
Higher secondary.
Just because you have discharged some duty,
Yes.
my lord,
in the graduation level,
Graduation
it will not become your entitlement.
Therefore, they regularize me. They give me the full pay scale of the degree level.
Okay.
And even allow me to contribute provident fund.
Regularization, your appointment is one section and regularization in a different section.
Yes.
No, my lord. That is totally incorrect, my lord.
It is there in the record. And now, therefore, they say.
I mean, like there is a factual dispute also.
They say they don't have a computer application degree level.
Now, why you are asking for a records? Why you board?
Now, with regard to now, first the secondary level, class 11 and 12, since the Lordship asked him to bring those instructions, and his instruction is not clear, therefore, record will show.
No, the Learned Council says that there is no vacancy insofar as the degree level is concerned. But then there,
not degree level.
It is
class 11
higher
and 12.
secondary section, my lord, because
no vacancy higher secondary.
Yes, my lord.
And for degree level, he is not.
Because
or
there
not
is no, my lord, department as far as the
degree level, the department itself.
Not there. It's not there, my lord. From the very beginning, my lord, it's not there. It is only because the HS section and higher the degree level was together, my lord.
Things become.
And petitioner was serving some certificate courses, my lord, under the RUSA, my lord. So he is claiming that, my lord, there is a computer degree, my lord. For which, my lord, he has been additionally remunerated, my lord.
What about the conferment of higher pay scale and all?
Yes.
That was, my lord, done at that point of time, my lord, because he was serving and the duties at par with other teachers, my lord, other similarly teachers. So,
But
my
then
lord,
it was on temporary basis.
my lord, on temporary basis, not to, my lord, to give him the fruits
Once he
of
is
his
absolved
service.
of this duty, that extra benefit also goes back, isn't it? That extra duty which he performed,
My
for
lord.
which he was given extra pay, moment that duty is over,
My lord.
that extra payment is also. That is what the thing.
Now the record, Lordship, I
It
prayed
seems
for
quite
the record.
logical. What is
My lord,
your original lien, if you at all appointed, that remains with the post where you appointed.
my lord.
It is not that where you serve on deputation basis or where you go or where you are asked to, you see, perform some extra duties.
One more aspect, my lord, if I may.
That is, my lord, my prayer is, though I was inducted for class 11 and 12 and allow me to perform both, and my regularization, the pay scale granted to me is a degree level.
At the time of regularization.
Yes. And thereafter changing the nomenclature from lecturer to assistant professor also.
Downgraded your pay.
It was given to me, assistant professor. That designation is not available to class 11 and 12 teachers. And secondly, they say that there is no computer application department in the college, degree level. It is very much there. Now, there are two types of, my lord, departments. One is a computer application, my lord, then recognized by the university. Here it is not recognized. If it is not recognized, if it is recognized, then there would be a PCA, Bachelor of Computer Application, for 3 years. Course will be there. They propose for that universities, they don't have an infrastructure.
If it is recognized by the university also, are they bound to have those courses in their college?
Once it is recognized, my lord, and they fulfill the infrastructure, college will appoint a qualified lecturer and impart that.
But then as of now, the submission is that there exists no such department.
My lord, I do admit it. I don't dispute it. That is the first computer application, the course, normal course. Now, in absence of that PCA, Bachelor of Computer Application, Even there are short-term skill courses imparted by university, by the college, not only this college. Other colleges also they do impart, but that may not be necessarily recognized by the university. The college by itself, from the fund of the college itself, and sometimes grant from the UGC, the central government, they impart the skill-based computer application. Computer. I was engaged for that. And when they sought for accreditation, my lord, upgradation of the status of the college, the college has furnished to the government of India that there are 6, 8, 10 courses are there. We also disclose computer application is one course they impart. Position of the faculty member, they also mention one, that is me. They furnish all this. So if there is no computer application from the beginning, how they furnish those particulars to the government of India and get the upgradation of the status of the college and get more fund?
Now,
so
let us assume that computer department exists there.
Yes.
Then who is serving there? Some person will be needed.
My lord,
who are they?
Yes. I was informed of the filing, my lord. There was one staff is engaged temporarily and impart the short-term certificate courses to many students till today. Only that they change.
So they are lying before the court.
The syllabus also have an X. They lie, open lie.
You know the consequence of false statement before court.
Only the name of the course is changed.
Now, name has been changed. Now that is also, see, one relevant factor. They have, now, then you cannot say. It is not that, you say like how that would be. If that department is retained, they will come to the court and say this is not retained. I don't think, do not expect for an institution, this will be too much. Because this will be revealed. You see, they cannot lie to that extent. Now you said name has been changed. Now name has been changed from what to what?
Name of the syllabus matter. May I just show the syllabus, name of the syllabus change is there in the government. May I just point out. My lord, it has been changed to go to your website. And this is one of the computer application course imparted by the college till today. And many students are getting...
Go to your website.
Yes.
So and computer department has been renamed as a go to your website.
Yes. So content of the syllabi or the syllabus is remain the same. Another third person is engaged. I was ousted.
So that was done intentionally to oust you?
My lord, that is the case, my case. Therefore, let them produce the records. The entire records. Furnishing the Union of India also. In the present records, how many students are they getting this short-term computer application?
No, which basis this court will conclude that these are same departments renamed?
My lord.
If in the event the dispute that these are two different things. My lord. Now go to your website, you have that department. Is it a name of a department? Can it be a department be named like this?
My lord, these are short-term courses, my lord, and for this, my lord, even if it is, my lord, for this, my lord, there is no department required, my lord. Full-fledged computer department is not required, my lord.
To impart that thing.
Short-term courses, certificate courses, my lord.
I was engaged for that short-term courses.
And he was remunerated for those additional...
You were under department, certain department. Now that department is not there.
Department, they call it the computer application department. But the same syllabus,
no,
the same
things,
course.
Mr. Sangre should just tell us clearly the department which, is it your case, the department in which you work, that department is in existence?
Yes, it is still in existence.
That is your submission, or you want to say that though that department has ceased to exist, but the court imparted, the courses which are imparted under the department, that remains.
My answer is, my humble answer is, department remain the same. Syllabus content of the teaching is the same. Only the name of the title of the department is changed. Now, what is essential is the content
existence
of the
department would mean the continuation of something permanently. But then continuation of a course without an existing department means that would be temporary. Is it correct?
My lord.
I mean, like...
Right. If they say that you are engaged for the short-term courses for 8-9 years, and since there is no such courses, we abandon that one and from today onward they are not imparting any short-term courses, then that is case. There is no more department anymore. That is not the case of the college. The college still impart the short-term skill development in
that, my lord,
application.
my humble submission is a department is not required, my lord, for certificate courses, my lord. What my lord?
No, but then
submitting, my lord.
for this thing, imparting this thing, those education in this for those courses, you'll be needing people, isn't it? Yes. So why to replace him? Yes. Why to oust him and keep somebody else?
Yes, that is the issue.
To that, you may have discontinued the department,
my lord.
Okay, but then retain certain courses. Okay, now for continuation of those courses in colleges, you'll be needing manpower, isn't it? You'll be needing somebody, instructors, teachers, for imparting education.
My lord, at that relevant point of time also, my lord, the petitioner was serving on temporary basis, my lord. Purely temporary basis, my lord. That is my submission, my lord.
Different phases of
my lord.
These things.
So he doesn't have any right, my lord, to come before this court and claim right.
This is a private institution.
Private institution, my lord. Private institution, and his post is completely, my lord,
whether
funded by the management.
Has the approval of any this thing, university or board or
no, it is not.
any government approval?
No, my lord. No, my lord. Private.
The scale conferred is it prescribed by pay scale?
The scale, my lord, by the college, my lord, by the management, my lord.
3 classes of teachers are there in the college.
It will come. This rate will be maintainable.
No, my lord. In my humble submission, it is not maintainable, my lord.
It is maintainable. He said not maintainable. There is no government.
First of all, my lord, we won't come under.
They have not challenged the maintainability.
They are not challenging the petition in the.
My lord, okay. I am disputing. I am challenging, my lord, the maintainability, my lord.
In his government. But according to me, this maintainable.
You have not raised any thing in your petition.
My lord, I cannot. The question of maintainability, my lord, can be challenged, my lord, at any point of time. So.
No, it's definitely it's a question of law. It can be challenged. But then there is no. I mean, like you have not raised that specifically in your opposition. It should not be something like that just because court raises it, you should challenge it.
No, my lord. From the very first day, my lord, I have been raising.
You become an opportunist and you say, now I have the opportunity.
That is what point which I have been raising from the very first day, my lord.
Mr. Shanglisho, what record of ambush is to do here?
My lord, with regard to class 11 and 12.
No, my lord.
Otherwise, my lordship.
What class 11 and 12 means, like what this record would project exactly?
Even
last occasion, lordship directed him to take instruction as to how, since you offer him full-time scale.
That was the submission. They said that they can offer you.
Yes.
Okay, some position in the higher secondary direction, but not in the graduation level.
Yeah, not graduation level, and I turned down. That is the submission.
That was
therefore, lordship said that since the petitioner is looking for a job, so why don't you take instructions as to how many vacancies are there in the higher secondary level.
Yes.
That was it.
No, whether you can be accommodated there or not. That is what.
That was only the query, my lord, from the court. Whether yes, my lord, whether he can be accommodated or not. And my lord, the higher secondary section is also, my lord, managed by the managing committee, my lord.
Then we have to go to the details of the case.
Probably
it seems that will not be a simple matter because it has different phases, the existence of department and then other aspects. Anyway.
I am ready, but only my prayer. Record may be essential.
What is not required, my lord, in my humble submission?
They are lordship.
A record for the purpose of
computer application.
No, but then what the record? What for you want that record? Determination of
the fact that computer application is still in existence from the beginning till today.
No, but then if it is in the graduation level, how board will have this record?
Okay, for the time being, my lord, if lordship do not want, leave aside for the board matter.
No.
Let us focus on the graduation level. The graduation level, my lord.
Your claim for appointment in which section? Which
graduation
part?
level. Graduation level.
No, but then you say that the person who is imparting education in graduation level is also imparting education in the higher secondary level. Then how can there be separate post for these two?
That is why, my lord.
Seems things to be very, I do not know. You say like that way court will end up, like more confused.
Therefore, lordship, if lordship.
Now, the vacancy, do you want to say there are two vacancies exist? One is the higher secondary section and other in the graduation level?
My lord, it should be, my lord.
Should be cannot be basis. See, Mr. Shanglisho, the court must have a clear picture.
But only the instruction.
What are the vacancies which are in actual existence, that is what court wants to know. Okay, now what should be or should not be not on the basis of that.
For college level, degree level, one post from the beginning till today. It is
College degree level. It is meant only for degree level.
For degree level.
So it means the person, those who are there, then they do not impart any service in higher secondary section and below.
That we don't know whether that gentleman who is teaching in the degree level, skill course at degree level, whether he is also teaching in the...
Who is that gentleman? This gentleman is a party here.
My lord, we have a mention, my lord, his name.
Now this gentleman is occupying your post or not?
We come to know, my lord.
The gentleman whom you are talking about, whether he is occupying your post or not?
But that, my lord, whether he is occupying my post,
now, say supposing, if you say that you have been ousted, but then your functions remain in the thing and that is performed by somebody else. That has to be something like that, isn't it? Even after the discontinuation of the department, the courses imparted that remains. So there must be somebody who is imparting this thing, teaching there, isn't it? They're teaching there, isn't it? Now, it means like your job is being performed by somebody else.
I just take that instruction regarding that particular instruction. If he's teaching there, my lord, the consequence would be different.
See, Mr. Shangneshu, say supposing, assuming, if your submission is to be accepted, if you dispute their version that this department has been discontinued, and as such there is no requirement of, like keeping you in service. If you say that yes, no, in reality department is remaining, in such a case, somebody must be imparting education there. Who is that person?
My lord, may I just ascertain, my lord? Give me 2-3 days, ascertain it, and
this matter seems to be very confusing for the court. Court has not.
And if necessary, I will implement it
now.
Whether
there exist two different posts for the degree level or the higher secondary level, whether it is one post. And if you say the department is retained, you have been ousted. If the department is functioning, how can it be function without any person? They will be needing manpower.
They need manpower.
So we do not have any clearer person who is serving there.
May I just obtain that particular gentleman? If he is particularly
tell us what was your source of how you were taken into service? Was there any selection process?
No, my lord. No, my lord.
There was no
selection process, no appointment letter, nothing on verbal terms, my lord.
Therefore, 3 types of, my lord.
Private institution, you have been taken and you have been thrown out. Which way read court will be that thing?
My lord, I'll satisfy, my lord, that one. Three categories of teachers are there, lecturers are there. One are the aided teachers. Their appointment required for approval by the
because government is giving some
government is. Now, second category is the lecturer or assistant professor appointed by the college management itself and funded by the management itself, including me.
Total private entity.
Yes, pure. And third one is the faculty or temporary teachers, which they are saying that I'm temporary teachers. They are only these to pay the salary per lecture.
Even if you come under second category, can your right be enforced by a head court?
Well, I'll satisfy that. There are few judgment, my lord, where when imparting education.
What is your claim? You are an employee of the second category. You are second category.
Yes,
that is your claim.
Second category.
As per you.
Yes. And they say I fall into third category.
And then if you are a second category employee, how can your service be terminated?
What?
I mean, like, what are the procedures to be adopted in terminating your service?
But once I've given the status of permanency of service in that post, my lord, to remove me, my lord, there should be a fairness. Give an opportunity. Give me a show cause.
Is there any rule?
My lord, I'll try to satisfy it, my lord.
Approved rule.
My lord,
no, just see the court query is basically, since you have come by Article 226, the petition under Article 226, you may have your remedy somewhere else. It may be something like that you fall under category 2 employee, and there appears to be a set of rules which guides your service condition, and the manner in which you have been thrown out, that is illegal. But then the remedy may not be available here. Until unless there are statutory rules or law.
I'll bring the rules. I'll bring the rules along with the citations with regard to this particular queries. It is there. It is there. Only my prayer today is for the records. If Lordship
No, but
think
then
that
records,
record is not at all
for
required.
records, what embossed record will do?
Forget about the embossed record, my lord. Records of the university college level is important for the computer application.
To show that when it was discontinued and all those things.
Yes, yes.
It is not, you have not brought it in your affidavit. From when the department has been discontinued in your.
It is there.
They did not annex any paper. I have annexed in my counter, in my rejoinder.
Then why record is needed? If these are ascertainable from here, if you say that something is not correct, then we may call for the records. If it appears during the course of hearing. But then, what about the person who is serving at present?
That aspect, if Lordship give me 2 days time,
paragraph-
I'll take instructions, and if required, I will implement with Lordship permissions.
Mr. Shen must be wondering. This matter is very simple to him. Must be wondering why this.
Only thing, Your Lordships, well, I mean, university, how university is relevant here? Because they are saying, my lord, he was teaching in degree courses. He's in a department called computer science, application of computer science. Normally, the requirement is this: whether private college or otherwise, if they are imparting certain education leading to a degree, leading to a degree, that is a department. They cannot do it without being affiliated with the university. There is a way out. They will have to apply for it. University will come, inspect, look into the infrastructure, and once that is clear, then only they can do it. So Lordship's limited query was to find out whether this particular department was affiliated with the university. Now, my lord, we have checked from the records, it was never affiliated with the university. So there is no question. This particular department was conferring a degree. Ultimately, the exam is conducted by the university.
Mr. Sangresho, that goes against you.
Well, therefore, I don't make any prayer against the university.
No, there is no question making us. This basically
clear,
solve the issue of whether that department is in existence. If we go by Mr. Shen's submission.
The degree, the computers.
Even if you say there cannot be a lawful existence of that department, they may continue it. They like it.
But what a learned standing
without
council?
Recognition.
What a learned standing council making a submission is the former degrees imparted by the colleges under the university. But that doesn't preclude the colleges to impart short-term courses, skill courses without the affiliation of the university.
Recognized courses, isn't it?
Yes.
Who recognizes that course?
It is recognized courses.
Who recognizes
My lord, recognized by the government. And not only this is women college, St. Anthony's and many colleges are imparting this too.
But then how this recognition comes without anything? You start any course in your college and this will automatically have recognition.
It recognized. Government also recognized. It doesn't require recognition of the university.
This seems to be quite surprising. Just show us something.
It is not a degree course. It is not a degree.
Our consent, our affiliation, nobody can.
Now, even for other courses also, say supposing something below, to have a recognition, you see, I may have one private institution, I can start it, I can impart some education, and then at the academic career, I give the students some certificate. That may remain recognized for me only, but then it will not be recognized by all the institution. Now, to say that is a recognized qualification, it is recognized by the government institutions. Okay. Now, that is where. Now, Mr. Sangresho's submission says that the course which they are imparting may not be a course of degree level. But then whatever certificate or diploma course they are undertaking, these are all recognized. Now, who recognized? Recognized by whom?
But only the policy of the state government and the central government.
What does you say? Show us something.
My lord, therefore, if
they are not made a party, my lord, in these proceedings, my lord.
If lordship
that is
call
their
for the
Come to
record,
that first, let them show that the courses, whatever you are offering right now, has recognition. Now, what basis will determine it?
my lord, it is I have made averment, even annexed certain
No,
documents.
forget about averment. Just show us something low that this will be recognized. Your averment will not make this thing recognized.
My lord, the first question, if it is not recognized, not acceptable, how the college imparting this, my lord?
There are many private institutions, they are making money like that.
It is recognized.
This cannot be a basis.
It is recognized.
No.
I'll satisfy under the policy of the government.
But then if you say that it is recognized, recognized means this code, for this code, that it is recognized by the government. Okay. Now, if you say moment to have any course, recognized court, there must be some sort of affiliation, some sort of recognition. Otherwise not. They may impart it. You will find there are many institutions. They impart education. But then those certificates become useless.
My lord, that
so these are
honors, my lord, with due respect, that honors whether that course is valid or not valid. That honors to be proved lies with the management.
You are contending it is recognized.
Not the teachers.
It is you. Your burden of proof is on you. Go by 102 Evidence Act. See, it is you. You are alleging this is recognized course.
Therefore,
He said that they are imparting some courses. But then that may be, say, some sort of training program and all, and they issue their certificate of themselves. Whether it is recognized by other authority or not, they are not bothered by them. If you like to carry on with this, you carry on.
Government's evidence are there regarding this aspect also.
No, you have to show. You have to show this court to basically that to establish your contention that their courts are recognized. You have to show us something.
We will.
Your mere averment will not.
But you will rush to fix the
Your
matter next
averment,
week.
their denial. This is not a something like that. You see that they accept. Recognition will not come.
If rush may come up next week.
And please take information with regard to the present incumbent who is serving and how they are serving.
Yes, sir. I'll do that. It is easy, my lord. It is easy that they engage for 7-8 years and say that there is nothing. You go out.
Also, give us the information, please. Give us the details of the number of posts existing in your institution under the higher secondary section and also degree section.
I'll also obtain
This,
inspector.
Degree section is concerned because I wrote a letter to the university, so they have given me the details. So this can form part of the records. What are recognized courses, and but specifically we have.
Can you ascertain that how many number of posts are there? Recognize these things, the sanction posts. That information you will not have. University will not have. Now, from where we can get it? You can provide.
We will provide, my lord.
Please provide us. See, things should get simpler, my lord. You know, nothing should be decided on the basis of presumption and assumption, my lord.
Lordship, let them bring on record through affidavit.
No, but then you also have to do start. See, you do not shift your burden to them.
I would assume that. Lordship is sitting in a read
You
court.
shift your burden to them so that you can enjoy the fruit later.
Well, I cannot. Burden is with me. I invoke the writ.
My lord is adjourning the matter. So for university, my lord, this is only the limited purpose.
Yes, please, you can see like probably on the other day you had your associate these things. If you have this, though we cannot finish it today. So we'll be requiring some more information.
So what I am saying, my lord, university we do not have to say much, my lord, except this.
Yes.
Right also.
Let it remain. See, if you do not have time, Mr. Shen, you do not have to come personally. You do not have to come personally. You can depute anyone with the same set of instruction. Nothing more will be needed.
Knowledge.
So when shall we keep it?
Next week, if Lordship permits me, I'll take immediate instructions. And let my friend also bring on record how many faculties are there.
Yes, Mr. Chanda, 1 week will be enough.
My lord, 1 week should be enough.
Okay. Just say on the joint request of the parties, release this matter after 1 week. Mr. Shangresho, more simpler submission give, more would be better for this court to understand.
Since I invoke the writ jurisdiction, I have to satisfy them. I have to
So
proceed.
that would be better. See, like instead of creating confusion, like fact sums, the existence of post, and then like all those details, like where you were initially and when you were approved and all those things. If it comes in chronological order, things become simpler to understand. Otherwise, difficult. Okay, do not expect everybody expert like Mr. Shen, so far as service matter is concerned.
If Lordship clarify those points in the order, then my parties will comply with that direction.
What direction?
With regard to my lord, the third person who is teaching. So also the clarification with regard to the faculties how many teachers are there.
That he is bound to make it during the course of hearing. Without that, this matter cannot be decided.
My lord, better bring on record through affidavit.
It's not required, my lord.
Why should make this thing bulky? Have faith, an institution will not come and will make false deposition for the court. If you have any doubt, then we will call for the. If you can create a reasonable doubt,
yes.
It has to be reasonable doubt, not just on mere assumption. Okay. And if you say that they will have the status of a state under Article 12, then in such a case, there has to be a presumption of genuinity of their action. Okay.